the situation is that a cognizable offense has been occurred. You went to the police station. Police is not filing the FIR. Then you, as per section 154, subclause 3, you posted your complaint to the superintendent of police or either the commissioner of police. There also no investigation has occurred even after 1 month. Then what is your remedy? Now for that remedy, again we go back to the provisions of CRPC and we see we got a remedy there. Now what is your remedy there? Now as per section 156 of CRPC, subclause 3, the magistrate have the power to take cognizance of such offence. So what 156 subclause 3 talks about? Subclause 3 says, any magistrate empowered under section 190 may order such an investigation as above mentioned. So it empowers the magistrate as per section 190 of CRPC to order an investigation as above mentioned. Now what is as above mentioned? Now when you read the heading of 156, it says police officers' power to investigate cognizable case. So FIR has been filed. If FIR has been filed and you never wanted to go to superintendent of police or commissioner of police, then this must have been the procedure, right? So when police files a case, takes an FIR, then what is their power to investigate in a cognizable case? So subclause 1 says any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of chapter 13. And subclause 2 says no proceeding of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under this section to investigate. So it is basically just describing the power of the police to investigate the case under cognizable case. If not so, what is your remedy? Like as we discussed under section 154, the FIR is not filed. You had proceeded with the section 155 subclause 3. There also no investigation has been done. Then under 156.3, you got the remedy wherein the magistrate will use his or her power. Now 190, if you check, 190 says cognizance of offences by magistrates, because here magistrate of first class and magistrate of second class in certain cases are given power. So what is cognizance of offences by magistrate? In which condition, under which condition or under which circumstances the magistrate shall take cognizance? Now that is what given under section 190 of CRPC, which says subclause 1, subject to the provisions of this chapter, any magistrate of the first class and any magistrate of the second class specially empowered in this behalf under subsection 2 may take cognizance of any offence. So under these 3 circumstances which I am going to say, under that circumstances the magistrate can take the cognizance, the first class magistrate, and in exceptional cases the second class magistrate. So what are those circumstances? Upon receiving a complaint of facts which constitute such offence. B. Upon a police report of such facts. C. Upon information received from any person other than a police officer or upon his own knowledge that such offence has been committed. So these are the 3 circumstances under which the magistrate shall take cognizance. Now as in section 1 it has been stated that the second class magistrate can be also specially empowered. How that can happen? Now subclause 2 talks about the same, that the chief judicial magistrate may empower any magistrate of the second class to take cognizance under subsection 1 of such offences as are within his competence to inquire into or try. So there the second class is specially empowered by the chief judicial magistrate to take cognizance, or else all the time normally the first class magistrate have the power to take cognizance of the cases which has been described under A, B, C of section 190. So this is what basically they will do. Normally they will go with the power to take cognizance is under 190. Now, once you understand that police case is there, that is FIR is not filed, you are going to the superintendent of police, then commissioner of police. There also no investigation. So where you go? With the magistrate. Now, while going to the magistrate, what all you need to have? So first of all, you need to have the copy of the FIR. So that has to be in written format. So I have told you that under section 154 subclause 2, you have the right to get the copy of the FIR. So either ways, if you're filing a complaint, get a copy with you and then only file the complaint or whatever it is. So always make sure that you have the copy of the same. Secondly, you have posted the same to the commissioner of police or the superintendent of police. So you have to also have the postal address or the receipts of the same, so that you can prove that you have exhausted all the local remedies and thereafter you came before the magistrate. Then only the magistrate in such cases will take the cognizance of the case under section 190, as it has been given power under section empowered under 190, as it is a given remedy to you under section 156 subclause 3. Thereafter, the magistrate, now the magistrate, what she or he will do after you gave the all this basic requirements, you have completed the same. Now after that, the magistrate, what she or he will do is that either it will direct the police to investigate the case, file an FIR and submit a police report, that is given under section 173, that is final report, to the magistrate, or it may take cognizance of the case as per section 200 of the CRPC. So before filing the complaint to the magistrate, you have to determine under which magistrate, first class magistrate, you have to file the complaint, so that you can determine by seeing under which police station you have filed your case. So every police station comes under magistrate, so there will be lots of police station coming under one magistrate. So if your police station comes under that magistrate, then that magistrate have the power to issue directions to those police officers to investigate the case, or either consider the matter and go further as per section 200. So always remember that you have to take care the jurisdiction of the magistrate court in which you are going to file the complaint. Jurisdiction means which court have the power to take cognizance of that case. Okay, so this is something which you can't forget about. So in the previous video, I told you that determining the jurisdiction of the magistrate is so important. So you are before the magistrate. Now you go wrong in determining the jurisdiction of the magistrate. So what will happen? So the magistrate basically will give back your complaint and will tell you that this court will not have the jurisdiction to take the cognizance of the matter. So hence you shall take back your complaint and file the same to the appropriate magistrate court. If not so, and you are at the right place, this is the magistrate wherein you should file this complaint, then in such scenario there are two things which can happen. Either you will give a oral complaint, oral submission, so you being the complainant and the witnesses will be called before the court, and the court will take your submissions on oath and will reduce that in writing, or else you will file a written complaint. Now generally in day-to-day practical sense, normally the magistrate will only take the written complaint, so the oral submissions are not followed anymore. Always the written submissions are more encouraged. So once the written submission is given, chapter 16 of CRPC will be followed. If this chapter 16 will only be followed if the magistrate feels that this case or this offense has been committed and I am ready to take the cognizance, and the magistrate is not going to 173 or for the investigation, she or he is not directing the police officer to do the investigation of the case. Then only they will go to chapter 16, that is issuing of process, in which summons or warrant will be issued. Now what if the magistrate feels that no, there is no case and I am not also directing the police officer to investigate the case, I will dismiss it. So basically under section 203, the magistrate will dismiss the complaint. So now your grievance is that you know that you had a case and the police officer is also refusing to take FIR. The superintendent of police or the commissioner of police is also not taking the FIR. You came before the magistrate, proper magistrate, and the magistrate is also not taking the cognizance of the case, as it is empowered under section 190 and it is taking proceedings thereafter under section 200. So under section 203, she or he is dismissing your case. Now what is your remedy? So under that, under section 397, you can file a revision to the High Court of your state, stating that this all thing I have followed, all the remedies has been exhausted, and I have a cognizable case, but however, all the other mechanisms or all the other judiciary institution as well as the executive institution is not taking up my case, and I am the aggrieved person and the case must be taken. So the High Court will consider the matter. Now let's talk about the accused. Now where the accused will get a role to play. So if under section 156(3) you are making the complaint to the magistrate, and magistrate had taken the complaint under section 200, then she or he is not dismissing the complaint, then under section 204, that is chapter 16, she or he have to follow the procedure, and they are following. So after the issue of summons or issue of warrant, the accused will come into picture and then he or she can defend. However, if dismissal of the complaint happened under section 203 and you went for the revision under section 297, then there the accused have the right to be heard. So after hearing the accused, only the High Court can pass any order. That is not same under section 200. Okay, so before 204, issue of process or summons, the accused do not have any role, but however, it is not so under section 397. So this is all about the criminal procedure which is followed in India